Since when is who you voted for a proper question for agents to be asked?
I don't know what allegation you're referring to, Senator. If it's from an ongoing matter in litigation, I can't discuss that. But what I can discuss is I can only speak to the FBI's background investigations. There are other background investigations conducted across the government.
June 18th, Washington, D.C. A Senate hearing room turned into something much sharper than oversight. It looked less like a routine question period and more like a courtroom where the witness chair had suddenly become the hottest seat in federal law enforcement. Senator Sheldon Whitehouse looked across at FBI Director Kash Patel and put a number on the table that landed like a hammer. About 60 names on what Whitehouse called an enemies list, and roughly 20 of them, according to Whitehouse, had already faced some kind of adverse action after only 7 months of Patel's leadership. That is not a small clerical issue. That is not office gossip. That is the kind of number that makes the public ask a dangerous question. Is the FBI still enforcing law, or is someone inside it keeping score? This was not a normal hearing. This was a stress test for the most powerful law enforcement agency in the United States, led by a director whose words now had to survive public scrutiny, legal precision, and political pressure all at once. Sheldon Whitehouse was not questioning a random official. He was questioning Kash Patel, the FBI director, the person responsible for an institution that can investigate citizens, vet nominees, guard national security, and shape the fate of careers with a single internal decision. And Whitehouse did not start softly. He went straight at the contradiction. Patel said he did not have an enemies list. Whitehouse answered with the facts as he framed them. There was a list, there were names, there were adverse actions, and the timeline was moving fast. That is the first problem. Because when a powerful official says there is no list, but the surrounding facts keep behaving as if a list exists, the denial does not close the case. It opens it. And once that door opened, the hearing stopped being about political theater. It became about whether federal power was being used like a badge or like a weapon. Then Sheldon Whitehouse turned the hearing away from the headline and into the machinery underneath it. Because the danger in a moment like this is not only that a powerful man may deny something, the deeper danger is that he may deny it in a way that sounds official enough for people to stop asking questions. Kash Patel's answer was clean on the surface. He said the premise was inaccurate, he said he did not have an enemies list, and he said personnel actions at the FBI were based on merit, qualification, and the ability to uphold constitutional duty. But that answer created its own problem. Because when Senator Sheldon Whitehouse put the count on the record, about 60 names, about 20 adverse actions, 7 months in office, Patel did not walk the committee through each category. He did not say which actions were unrelated, which people left voluntarily, which cases involved documented misconduct, which decisions were pending before career officials, or which claims were false. He reached for the broadest shield available, merit. And merit is a powerful word inside government, but only when it comes with paper behind it. That is where the prosecutorial frame begins. A prosecutor does not just ask, "Did you do it?" A prosecutor asks why the timeline looks the way it looks, why the same names keep appearing near the same consequences, why a denial avoids the specific numbers sitting in front of everyone. Patel's statement may have sounded firm, but firmness is not evidence. A locked jaw is not a receipt. A categorical denial does not erase a pattern if the pattern is still visible on the table. And then Whitehouse moved to the grand jury testimony, and this is where the hearing became more dangerous for Patel. During the earlier confirmation process, Patel had appeared to suggest that some kind of court order limited what he could say about his own grand jury testimony. That kind of answer matters because it sounds like law. It tells the room, "I would answer you, but a judge has tied my hands." It creates a wall. And most people do not push through legal walls because they assume the wall is real. But Whitehouse came back with a receipt. He cited Judge Boasberg and the rule that mattered, Federal Rule of Criminal Procedure 6E. The point was simple enough for any viewer to understand. A witness is generally allowed to discuss that witness's own testimony. So the question became brutal in its simplicity. Was there any court order of any kind stopping Kash Patel from discussing what Kash Patel himself told the grand jury? That is not a technicality. That is the center of the credibility test. Because if there was no court order, then the earlier suggestion did not merely confuse the issue, it protected Patel from answering. It allowed him to borrow the authority of a federal court without showing that the court had actually placed that restriction on him. And in a hearing room, that is not a small move. That is the verbal equivalent of holding up a badge that may not say what the public was led to believe it said. Patel answered by saying the transcript had been released pursuant to his action. But notice what that does and does not answer. It says something happened later. It does not clearly explain whether anything stopped him before. It does not fully repair the earlier implication. It does not erase the moment when the committee was told, in effect, that the law was standing in the way. And that is why Whitehouse's line of questioning mattered. He was not just trying to score a viral clip. He was forcing Patel to confront the difference between legal secrecy and strategic vagueness. One is a legitimate boundary. The other is a smoke machine. The moral issue here is bigger than Kash Patel's tone, bigger than Sheldon Whitehouse's aggression, and bigger than the usual partisan shouting match people expect from Washington. The FBI is not a cable news panel. It is not a campaign office. It is an agency with files, badges, background checks, investigations, and the power to alter lives quietly. When the director of that agency gives an answer that sounds legally final, the country has to be able to trust that the answer is not just carefully worded fog. That is the pressure Whitehouse built in this hearing. Not one dramatic accusation, but a chain of unanswered questions. If the enemies list was not real, why did the numbers look so alarming? If the personnel actions were clean, where were the specifics? If a court order blocked Patel, what order was it? And if no order blocked him, why did the public hear language that made it sound like one did? And once the hearing moved into background investigations, the whole room shifted again. Because this was no longer just about what Kash Patel personally remembered, personally denied, or personally wanted to call inaccurate. Now Sheldon Whitehouse was asking about the system itself, the machinery that decides whether powerful nominees are properly vetted before they are handed public authority. That is where the stakes become colder, quieter, and more dangerous. Whitehouse raised the case of Jeanine Pirro, a U.S. attorney nominee, and he did not bring it up casually. He pointed to statements that reportedly came from Fox News executives in a civil proceeding where Pirro had allegedly been described in brutal terms, a reckless maniac, someone who made insane comments, someone colleagues did not trust to be responsible, someone with a taste for random conspiracy theories on weird internet sites. Those are not minor personality notes. Those are warning flares. And when the FBI conducts a full-field background investigation, the basic expectation is that warning flares do not vanish into the ceiling like cheap smoke. So Whitehouse framed the problem with the precision of a prosecutor laying out 3 doors. Door 1. The FBI background investigation did not find the information. If that is true, then the public has to ask why an agency with the power and resources of the FBI missed material that later became visible in public litigation. Door 2. The FBI found the information but did not report it to the administration or the committee. If that is true, then the problem is not incompetence. It becomes concealment, filtering, or institutional failure at the exact point where transparency is supposed to matter most. Door 3. The FBI found it, reported it, and the administration moved forward anyway. If that is true, then the hearing becomes even uglier because the issue is no longer whether the system worked. The issue is whether the system worked, delivered the warning, and the warning was ignored. That was the trap, not a rhetorical trap, a logic trap. Kash Patel responded by saying background investigations are not publicly discussed, that adjudications are handled by career professionals, and that those details do not flow through him personally. On paper, that sounds procedural. In a normal setting, it might even sound responsible. But inside this hearing, after the enemies list denial and the grand jury fog, that answer did not settle the question. It pushed the question deeper into the building. Because oversight does not exist, so officials can say, the system handled it, and then close the blinds. Oversight exists precisely because the system sometimes hides behind its own walls. And when a senator asks whether serious derogatory information was found, missed, buried, or ignored, the public deserves more than a polite tour through the organizational chart. Then Whitehouse moved to the alleged pause in FBI background investigations for Trump nominees. According to the complaint he referenced, Emile Beauvais allegedly directed the FBI to pause background investigations until Kash Patel was confirmed on February 20th. That detail matters because timing is evidence. An 8-day pause may sound small to someone watching casually, but in government, timing can be the whole crime scene. Pause the vetting process at the right moment, resume it under the right leadership, and suddenly the question becomes obvious. Was this administrative delay, or was it political control wearing a bureaucratic mask? Patel said he could speak only to the period after he arrived, and that background investigations had been ongoing across the board since then. Whitehouse pressed him. Was he told about the pause? Wouldn't an 8-day interruption in background investigations for major nominees be something a new FBI director should know? Patel said he did not recall. And there it was again. Not a full explanation, not a clean timeline, not a document, not a name, just the softest landing pad in Washington. I don't recall. But the most morally explosive moment came when Whitehouse raised the allegation that internal employee reviews included questions about whether senior FBI staff had voted for Kamala Harris in 2024. That is not a normal workplace question. That is not a performance metric. That is not merit, qualification, or constitutional duty. That is the kind of question that turns public service into a loyalty test. Patel rejected it. He said it was not a proper question, and under his leadership, the FBI did not ask who agents voted for. That answer was important, and it needed to be said. But the fact that the question had to be asked in a Senate hearing is already a sign of institutional damage. Because once federal agents begin to wonder whether promotion, termination, or survival depends on a ballot choice, the damage is not theoretical. It reaches into every office, every internal review, every career decision. It tells people that law may be written in public, but power may be sorted in private. And that is why this hearing kept getting heavier. Sheldon Whitehouse was not simply accusing Kash Patel of bad answers. He was exposing a pattern where every serious question seemed to meet a wall: denied, delegated, not recalled, not discussed, handled by career staff, ongoing litigation, internal process. Each phrase may be defensible alone. Stacked together, they start to sound like an institution refusing to let sunlight reach the floor. And this is where the hearing leaves the room and lands on the country. Because the real victim in a story like this is not only one fired official, one nominee, one senator, one director, or one political faction trying to win the afternoon. The real victim is public trust. The real victim is the citizen who is supposed to believe that the FBI does not ask who you voted for before deciding whether you belong. The real victim is the agent who spent years serving the institution and suddenly has to wonder whether loyalty to the Constitution is being replaced by loyalty to a political camp. In my view, that is the deeper lesson. A democracy does not collapse only when someone announces that the rules no longer matter. Sometimes it weakens when powerful people keep saying the rules matter while using procedural fog to avoid proving that they followed them. That is why Sheldon Whitehouse's questions mattered. He was not asking for theater, he was asking for a record. Names, dates, decisions, orders, pauses, reports, who knew what, when they knew it, and why the public should believe the system was not being bent behind closed doors. Kash Patel may deny the enemy's list. He may say background investigations are handled by career professionals. He may say he does not recall the pause. He may say political voting questions are improper. But after this exchange, the burden is no longer carried by tone. It is carried by evidence. And if the evidence is clean, release enough of it to prove the system still works. If the evidence is not clean, then stop treating oversight like an inconvenience and start treating it like the alarm bell it is. Because this is not only about Kash Patel, it is about whether federal law enforcement remains a neutral instrument of justice or becomes a private blade for political revenge. And if the FBI can be turned into a scoreboard, then what protection does any ordinary American really have left? If you think this hearing exposed something bigger than politics, hit like. Drop your thoughts in the comments, share this video, and subscribe for more hearing breakdowns.